Thank you, Mr. Chair. Committee, I think I'm going to let Mr. Gold go ahead and introduce himself and do some of the talking on this bill.
All right, Mr. Dolden, you're recognized. If you would state your name and the organization you represent, and then you may make some comments on Senate Bill 294.
Absolutely. Thank you so much, Mr. Chairman. My name is James Dold. For the record, I represent the Campaign for the Fair Sentencing of Youth. I just want to note at the outset, and thanks so much, Representative Petty, for working with us on this bill, as well as Senator Ervin. This is a bill that is a very difficult and tough issue, and it deals with how we treat our young people when they're convicted of very serious crimes. And so we are so honored to be here at the table with Representative Petty and with Senator Irving to present this very important issue before the committee. I thought I might just start off by giving a little bit of a history about this issue and sort of why we got to this point and what some of the legal ramifications have been because of some recent U.S. Supreme Court decisions that have come down. So back in the late 1980s and early 1990s, there was a juvenile crime wave that happened, and there was a group of criminologists that theorized that there was a new group of super predator children who were coming of age who were more violent and less remorseless than ever before. These children were characterized as being godless, jobless, and fatherless. And these criminologists had urged state legislatures to pass laws making it easier to transfer children into the adult criminal justice system. One of the unintended consequences of many of these laws is that it opened children up to extreme punishments like the death penalty and like life without parole sentences. So fast forward about 15 or 20 years, and the U.S. Supreme Court begins to weigh in on the constitutionality of some of these sentences. So throughout my presentation, there's a couple of different ways that committee members can look at this issue. There's the legal lens, which looks at this issue through the Supreme Court jurisprudence on this issue. And then there's the moral lens. And I'll talk in depth about both of those. Starting first with the Supreme Court, in 2005, in a case called Roper v. Simmons, the U.S. Supreme Court found that it was a violation of the Eighth Amendment's prohibition on cruel and unusual punishment to sentence a child to death. The underpinning of this decision really rested upon the fact that there were fundamental differences between juvenile and adult brains. This is something that the court noted that every parent knows, but the laws really hadn't caught up with at that point in time. And in particular, the court noted how the prefrontal cortex, which is the part of the brain that's responsible for emotional control, it allows us, it's sort of the executive functioning part of our brain, isn't fully developed in juveniles, the same way that it is in adults. As a result, children actually used a more primitive and a more emotive part of their brain called the amygdala to process information and make decisions. It was one of the reasons that the court noted for why the penological justifications, that is, retribution and deterrence, are diminished in light of children's diminished culpability relative to that of adult defendants. And so it was on that basis that the Supreme Court strikes down the death penalty for child offenders. 5 years later, in a case called Graham v. Florida, the U.S. Supreme Court took up a case called the court took up the issue of whether or not children can be sentenced to life without parole for non-homicide related offenses. There again, the court, relying on its kids are different doctrine that it established in the Roper v. Simmons case, found that it was in fact a violation of the Eighth Amendment's prohibition on cruel and unusual punishment to sentence a child to life without parole for a non-homicide offense. In that case, the court likened life without parole to the death penalty in many ways for a child because no matter how much a child changes, no matter how much they're rehabilitated over time, no matter how much remorse they express, they will never have an opportunity to live in free society. The only way they will leave prison will be in a pine box. 2 years later, in a case called Miller v. Alabama, which had a companion case that originated here in the state of Arkansas called Jackson v. Hobbs, the court took up, at the time, what we thought was mandatory life without parole sentences for juvenile offenders. And those were juveniles convicted of homicide-related offenses. There, the court said that individual judges have to have the ability to consider the mitigating factors of youth before imposing the nation's harshest possible punishments. The court went on to opine that these sentences, if they're ever imposed, should be very rare and very uncommon. In the wake of the Miller decision, there was a lot of questions as to whether or not that decision was meant to be applied retroactively. And last year, the U.S. Supreme Court, in a case called Montgomery v. Louisiana, answered that very question in the affirmative. The court went a little bit further, though, in the Montgomery decision, not only did it say that the court say that that Miller applied retroactively, but the court went on to say that a lot of us were actually misinterpreting and misreading what Miller actually stood for. And what the court specifically stated, and I want to read a couple of quotes to the committee because I think it's relevant for the purposes of this conversation. The court specifically said that Miller determined that sentencing a child to life without parole an unconstitutional penalty for a class of defendants because of their status. Even if a court considers a child's age before sentencing him or her to a lifetime in prison, that sentence still violates the Eighth Amendment for a child whose crime reflects unfortunate yet transient immaturity. Miller barred life without parole for all but the rarest of juvenile offenders, those whose crimes reflect permanent incorrigibility. Miller's conclusion that the sentence of life without parole is disproportionate for the vast majority of juvenile offenders raises a grave risk that many are being held in violation of the U.S. Constitution. So here in the state of Arkansas, there were about 110 cases that fit within the Miller and Montgomery framework. And to go through a resentencing for all of those cases would be vastly expensive and redundant in many ways, as the court has said that children cannot be subject, the vast majority of children cannot be subject to a life without parole sentence. What the court did, though, was it offered states a way out. They specifically stated, and I'll quote here, allowing those offenders to be considered for parole ensures that juveniles whose crime reflect only transient immaturity and who have since matured will not be forced to serve a disproportionate sentence in violation of the Eighth Amendment. Those prisoners who have shown an inability to reform will continue to serve life sentences. The opportunity for release will be afforded to those who demonstrate the truth of Miller's central intuition, that children who commit even the most heinous crimes are capable of change. So one of the easiest ways, and one of the ways that many states have been complying with these Supreme Court decisions, is simply to make all of the individuals who are impacted by these decisions retroactively eligible for parole. As a matter of fact, in the Montgomery decision, the U.S. Supreme Court cited to a statute from the Wyoming state legislature that did exactly the same thing. It got rid of life without parole for children and retroactively made everybody eligible for parole there after 25 years. So this is, the easiest and the cleanest way to comply with these decisions. So the impact of these decisions overall on the state of Arkansas, as I mentioned, currently kids cannot be sentenced to death. After Graham, they cannot be sentenced to life without parole for non-homicide offenses. And so what that means is that there's a number of offenses, Class Y felonies, for example, where a child right now cannot get a life sentence because of the fact that there's no possibility of parole for a life sentence. So the maximum punishment under Class Y felonies currently is to 10 to 40 years because there's no penalty in place for those kids. And then under Miller-Montgomery, the 110 individuals here, because there's no constitutional penalty in place right now, again, it's a 10 to 40 year or life if the court can determine that those individuals are permanently incorrigible or beyond rehabilitation, which we do not believe is a possible determination because we don't know who a child will be after 25 or 30 years in prison. So one of the things that SB 294 does is, from a public safety standpoint, for those Class Y felonies, prosecutors will still be able to pursue life sentences in some cases. It will just ensure that for the non-homicide cases, that individuals will have an opportunity to go before the parole board after 20 years. For first-degree homicide, individuals will have the opportunity to go before the parole board after 25 years. And for capital murder, they'll have the opportunity to see the parole board after 30 years. It's very important to note that this is not a get-out-of-jail-free card. This is life sentences will remain intact for all of the juveniles currently serving here. It's just an opportunity for them to see the parole board. One of the other things that we're also doing is making sure that good time does not apply to these underlying offenses. So that's one of the other things that's happening in the law right now, is that the good time statute currently applies to anybody who takes a deal or is resentenced. What this legislation will do is take away good time so that it's a flat calendar 20 years for non-homicides, a flat calendar 25 years for first-degree murder, and a flat calendar year after 30 years for capital murder. And again, that does not guarantee anybody's release. It just says that they have the opportunity to see the parole board, and we'll make sure that the state is in compliance with all of those decisions. And those provisions are in the bill, and I'm happy to answer any questions on them. I won't go through them. If people have questions, I'm happy to answer them. I do want to go through the moral aspect of this issue a little bit. Aside from what the Supreme Court has stated and why this is such an important issue to address from a legal standpoint, there's a lot of important moral issues for the state of Arkansas to pass this legislation. When we've done studies of these kids, in terms of the people that are serving life without parole sentences for crimes that were committed as juveniles, one of the things that is a recurring theme is that we often see that they are some of the most victimized people in our society. In a study that we did, one of the things that we found was that over 80% of the kids serving life without parole witnessed violence in their homes and in their neighborhoods on a regular and ongoing basis. Over 50% of these children were physically abused. Over 20% were sexually abused. For girls serving the sentence, over 80% of them were sexually abused. Over a third of them were homeless or transient at the time of the commission of the offense. Now, this does not excuse the underlying criminal conduct, but it helps us to understand the situations that many of these kids were growing up in, oftentimes coming from broken homes, situations where they were subject to abuse. So it's important for us to understand as background the types of kids that we're dealing with and how they ended up in these situations to begin with. The other thing that I'll note is that in many other areas of society, we treat children differently. We don't allow children to vote, to serve in the military, to enter into contracts, to get married. We also have special laws in place to protect them from predators and people who would prey upon them. And there's a specific reason for that. We recognize intuitively that children are more vulnerable. They're more likely to make risky decisions without thinking through all of the consequences. And we know how much people change over time. After all, who amongst us is really the same person any of us were at 14, 15, or 16? We all grow and change. So, and the last aspect that I'll say to this as well, we've worked really sort of across the country. 17 states currently ban the practice of sentencing children to life without parole, including neighboring Texas. I always tell people when you can get Texas and Massachusetts on the same page about sentencing policy, you're probably onto something that's truly bipartisan. But the states really run the gamut. Last year we worked in Utah and South Dakota. Both of those states banned life without parole for children. Before that, we were in West Virginia and Nevada. So this is something that has really shown a tremendous bipartisan support across the country. And again, it's a very easy way for the state to comply with these U.S. Supreme Court decisions. The last aspect that I'll highlight, a couple of years ago, many years ago now, we worked with former Speaker of the House, Newt Gingrich, on similar legislation out in California. And he wrote a really great op-ed out there for that bill. And one of the things that I was struck by in his op-ed is that, he said that as Christians, we are called to do unto others as we would have done unto us. If these were our children or grandchildren, what would we want done? Would we want them to have the opportunity, and just the opportunity, for a second chance? The Bible teaches us, too, that particularly for children, we're all capable of redemption and salvation. And from a moral standpoint, it's very important that our laws reflect our Christian values. Moses, David, the Apostle Paul were all guilty of killing, yet went on to serve God in very significant and important ways. And I always tell people that if our children are not deserving of our mercy, then who amongst us is? And with that, I'll go ahead and close out my testimony. I'm happy to answer any questions about the legislation or anything that I presented.
Representative Tosh, you're recognized for a question.
Thank you, Mr. Chair. Good to see you again, Mr. Dole, and appreciate your testimony. 2 years ago, you appeared before this committee, and with, I guess, the same type of legislation, and of course, this committee did not pass it 2 years ago. And I know the other day you met with me just briefly, and you said that you listened to our concerns 2 years ago when we really had some issues with that particular legislation that you had introduced or was trying to introduce then. And I guess for this committee and those in attendance, and more so for me, but would you just, as quickly as possible, just kind of tell me what changes you've made to address those concerns that we had 2 years ago as what you're presenting us today as compared to what we heard in the last session?
Absolutely. Thank you so much, Representative Tosh. James Dole for the record. So one of the very first things that we did was we increased the term of years. So before the bill was 30 years and 20 years. And so what we had tried to do in the previous legislation was make it so that individuals that have been convicted of felony murder would be eligible for parole after 20 years. So we increased that mandatory minimum term up to 25 years. So we made it a flat 25 years for that specific offense. The other thing is, when we first presented the bill in committee, we made a significant number of changes that we did carry over to this year. One of them was that under the previous law, it was a mandatory minimum of 28 years. So we increased that from 28 to 30 years. We also made sure that good time would not apply. So that was one of the really important things that we took out, made it a flat calendar years. The other thing that we added in there was protections for victims under the parole eligibility provision. So we made sure that anytime the parole board is considering these individuals, that there are very specific guidelines that they have to follow to notify victims and to make sure that they have an opportunity to come and present before the parole board. So we tried to take everybody's concerns that we heard before, encompass them into this bill, and make the penalties a little bit harsher from the time that we first presented the bill. The one other thing that we did do, and this was a recommendation from Representative Beck, who previously sat on this committee, was that we put in place a mandatory mental health evaluation, so that any time in the future when a juvenile comes into the system, a mental health evaluation has to be done at the time that they're convicted of the crime, as well as when the parole board is considering them, so that the parole board will have all the information they need to make informed, good decisions about whether or not this individual should be afforded a second chance.
Representative Charlene Fight, you're recognized for a question.
Thank you, Mr. Chair. You mentioned in here about brain development and how the brain is immature. A lot of brain development that I have seen tells us that the brain keeps developing up until around age 26. So are you going to be coming back asking for this to be extended to age 21 and then to age 24, then to age 26?
Representative Fight, for the record, James Dold, no, we will not be. Our organization focuses just specifically on child offenders. And I think that's really important because that's also where the Supreme Court has drawn the line at 18. While the brain does continue to develop into the early and mid-20s, there's a base level of development where we as a society recognize, and the American Psychological Association also recognizes, where people can make informed decisions, right? So, at 20 or 21, you're still going to have young people who make dumb decisions, but there's been more development that's happened in their brain than with a 17 or 16-year-old, for example. And so that's really important. So the brain does continue to develop, but there's a significant lack of development and a difference between, a 17-year-old and a 21-year-old, for example. And so that's one of the important things that the court has recognized, that, for people under 18 specifically, there's a lot less development that's occurred than in somebody who's younger, despite the fact that, there's some brain evidence out there that says that the brain keeps developing into the mid-20s.
Representative Drown, you're recognized for a question.
Thank you, Mr. Chair. It's actually kind of a two-part question. First part is, 2 years ago you asked me to support this, and why did I tell you I would not, or what would it take? She's sitting next to you.
Yes, you told me, as well as many people did, that we needed to work closely with Representative Petty and work closely with her to address her concerns and get her on board with this.
And the reason I asked that is, and you know why, because you approached me the other day and asked the same question, and I said, where's she at? And you said she worked closely with you. And Rebecca, if you don't mind, this is the type of legislation that I cannot support unless I have someone like Rebecca who has lived it as the mother of a victim. So anyway, I just wanted to let the committee know that, I will be supporting it, and that they've done a lot to make this a good piece of legislation. Thank you.
Any other questions from the committee? All right, we're going to move to the sign-in sheet. Okay, we have no one signed up to speak against the bill. Signed to speak for the bill is Xavier McElrath. Is it Bay or Ray?
That was very close.
Okay.
Xavier McElrath Bay. Thank you.
You're recognized. If you would state, you've already stated your name, but
Yes.
what organization, if any, you're with, and then you may make your comments.
So I'm Xavier McElrath. I work for the Campaign for the Fair Sentencing of Youth. I'm a senior advisor and national advocate, the same organization that James works for. First of all, I just want to say thank all of you for giving me this opportunity to share. My role here, honestly, I feel is a very humble role. I liked in some way to try to share with you what my experience was like and why is this reform is so important. I personally grew up in the justice system. That started very early on for me, being involved in the child welfare system. I was in group homes, foster homes, was in and out of detention. Unfortunately, by the time I was 13 years old, I had 19 arrests and 7 convictions. Most of my offenses were for armed robberies, aggravated batteries, assaults, multiple weapon charges, and mostly violent and gang-related offenses. At the age of 13 years old, I was arrested and I was guilty. I was guilty for first-degree murder. It was a gang-related incident that resulted in the unfortunate loss of another kid's life in my community, something that I was responsible for. At the time of my second court hearing, I remember the judge telling me that I was being transferred into the adult system. At that time, I didn't understand what that meant. But I remembered my next court date came, and they grabbed me, they took me down to the basement of the juvenile detention center where I was at. And they put me in shackles, and they put me along with other kids in the back of a van, and they escorted us to the Cook County Jail, which was actually the adult facility in Chicago. Beneath the courthouse, they took us into the Sally Port. At the end of that Sally Port, they opened it up, and we all walked in, I think, a single-file line onto an elevator, a very dark and gloomy elevator, I'll never forget. And we went up to I think it was the 3rd or 4th floor. We had to wait for a period of time. We were told that when we got upstairs not to talk to the other inmates, not to say anything to anyone, to stay looking forward and wait until we got into our bullpen if we had any questions. When we got into the elevator, we came off and waited for that period of time. My heart was pounding. I was scared. I was 13 years old. I was very visibly a child. Along with the other kids that were with me, that were present, we were very obviously very anxious and worried about what was to come. When we went up to the 7th floor, which was the courtroom where I was at, they stopped, and a few of us got off on that floor, and we had to wait for another officer to come to escort us to the bullpen. The bullpen is the holding area behind the adult courthouse. But before we can get to our adult courthouse, we had to pass a small corridor where the other bullpens where other inmates who were adults were being held pending their court hearings. I remember as soon as we turned the corner, we came in their sight. They started yelling profanity. They started saying a lot of bad words. And it was a roar from out of those cells, and they were shaking the bars, and they were visibly angry. And we got scared, and we started rushing towards the other door to get away from that space, but the guard had to open it with a key. We were all very anxious in that moment, but it took me a while to finally figure out what was being said and what their anger was. I thought it was like what I had seen on television so often about, adults trying to scare kids who were in prison. But instead, it was actually their anger towards the officers. And when I put it all together, by the time we got past that door and into our bullpen, I realized that the inmates were mad at the officers because they had kids like us being brought into their courtrooms. They saw us, we were all visibly children. At the time, I was probably 5'1", 5'2", weighing 110 pounds. Like, you wouldn't know. It would be no mistake about my age. And I think that when they saw us there, a part of them had become compassionate and angry and enraged. And they were yelling at the staff and the guards because they couldn't understand why kids as young as 13 and 14 and 15 were being forced to face the same judge, to have to be met with the same consequences, to face the same sentencing schemes. That's something I would never forget. What I would also never forget was the fact that in my heart, I always knew and felt that I was very guilty and responsible. In fact, I pled guilty. I pled guilty to murder when I was 15 after 2 years of continuances. When I pled guilty, my mother was allowed to come back to that same bullpen and talk with me. And I remember her crying, holding on to the gates. And I remember her telling me, "I'm sorry for letting you down." I remember her telling me that it was going to be okay, but yet she was crying more than I was. And I found myself trying to console her. And I remember saying, "Mom, don't worry about it. It's going to be okay. I'll be out one day. I promise you I'm going to go to school." I promised her things that I didn't really believe, to be honest with you. But in that moment, I wanted her to feel better. I didn't want her to see this. I didn't want to see her suffer because of the mistakes that I had made. And I said all I could, and I fought back my tears to make her feel better. But I remember thinking to myself, I don't know what's going to be the outcome. I knew that at some point I would be sent to the adult system. I knew at that time in my life I was still very heavily gang involved. But I told her what I could to make her feel better. Strange enough, the things that I had promised her, things that I told her I would do, those things did become a reality. Those things did become a reality because I began to mature and grow. With a 25-year sentence, I had a light at the end of the tunnel. I knew that although that seemed like light years away, I knew that someday, if I just stayed out of trouble, I could be free. And with that evolving sense of maturity and remorse, with a desire that began to grow more, that simple desire to come out and live a normal life, something I had never experienced, I saw that I was changing behind prison walls. The truth is that I was never really a monster. The truth is that I had so many horrendous and unfortunate experiences growing up. The reasons why I was in the foster care system is because we were taken away from my mother when I was 6 years old because of abuse and neglect from my stepfather. The reason why I was in detention for the very first time is because I refused to tell on my friend who had shot me in my face at point-blank range when I was 11 years old. Many things I experienced as a child, no child should ever have to have experienced those things. But in my heart of heart, I knew that as I began to mature and grow older, that I could not blame my mistakes upon that entirely, that I couldn't continue to place blame upon others, that at some point I had to take responsibility for my own actions, that at some point, if I ever wanted to live a normal life, I had to take control of my life and then make the right decisions. At the age of 18 years old, after spending a year in solitary confinement, I came out of that cell with a desire to live a normal life. And though I had several more years ago, I started to envision myself in a parallel universe. I started to envisioning what would my life be like if I was in free society? Where would I be right now? Well, I told myself I would have my high school diploma. I said, well, let me get my GED, and I did that. I said, where would I be when I'm like 21, 22? Where would I be if I was out in free society? I would have an associate's degree. Well, I did do that. When I was 24 years old, I was proud to stand up for my mother in a prison ceremony, a graduation ceremony, in which I was able to earn 2 associate degrees and a bachelor's degree in social science. This was the first time my mother had ever seen me graduate, because when I was arrested at 13, I was still in 7th grade. That was a beautiful experience that allowed me to dream and hope for something better. But what was different for me in comparison to those who are serving life without parole since childhood for similar offenses is that they don't have that light at the end of the tunnel. These individuals, no matter how much they grow, change, and mature, no matter how much they grow spiritually, they're not going to be given another opportunity to come out and to live a redemptive life. They're not going to be given an opportunity to come out and live a life that defines justice and giving back to their communities and making a difference. After 13 years in prison, I came out at 26. Since I've been out, I've earned a master's degree from Roosevelt University. I went back to my old community. I did violence prevention, gang intervention. I worked as a juvenile justice diversion program coordinator. Soon I went on to Northwestern University to be part and to join a clinical research team that looked at the mental health needs and outcomes of formerly incarcerated youth, much like myself. For 5.5 years, I was out doing clinical assessments and interviews with over 800 individuals who were no different from me. And I saw the hope and change that they had in their eyes. I saw the hope that came from being provided second chances. Soon after, I went from working with Northwestern to now joining a national campaign where I've been able to meet so many others, much like myself. Today, I'm very proud to say that I'm a member of the Incarcerated Children's Advocacy Network. Currently, we have 50 members in 21 states. All of these individuals, including some one in particular who's in this room, right, were once, much like myself, convicted of homicide-related offenses when they were children. Some of them were sentenced to life without parole. Some had multiple life sentences without the possibility of parole. But because of U.S. Supreme Court decisions and other legal interventions, they've been provided opportunity to come out, to reinvent themselves and recreate their lives, and demonstrate that they really were better than their worst act. That is nothing unique. I definitely don't consider myself as an exception to the rule. I know it's possible when kids are given another chance. And I just hope that the individuals here in Arkansas will be given that chance so that if they do change, if they do demonstrate maturity and their actions have demonstrated that they do want to come out and live a normal life, a redemptive life, that they be given a second chance. But if they don't demonstrate this, if they go before a parole board and they demonstrate that, in fact, that they have not changed, that they're continuing to break prison rules, continuing to be violent, to cause harm to others, that those individuals will not be given a chance. This is simply a way of looking back decades later and revisiting this person and seeing who they have become. And based upon that very, guided and very intentional review, hopefully that these individuals will have an opportunity that I was given. Thank you. I'm sorry, any questions? I'm sorry.
Thank you for your comments. I see no questions from the committee. Going back to the list, I believe we have one other individual signed up. Paul Kelly signed up to speak for the bill.
My name is Paul Kelly. I'm a senior policy analyst at Arkansas Advocates for Children and Families. I had a lot of comments, but some people have covered them quite well, so I'll be short. I know from my life experience as a social worker and also as a child advocate, the challenges that these kids face, which they have neither the power to escape from nor the judgment to understand and to resolve the impulses and the things that have already been talked about. By the way, my mother, who had 14 children, said you really can't tell how they're going to grow up until they're 40. So I made that, but anyway. The fact is, yes, we must hold these kids accountable, but we must realize that kids who are spending decades of their life in prison can, in fact, realize their potential to attain a mature understanding of their own humanity and their redemption. This bill is a rational, humane approach that I think, and Arkansas Advocates thinks, represents the finest aspects of our judicial system, and our organization urges you to support it. Thank you.
All right, I see no questions from the committee. I believe that concludes the list of individuals who signed up to speak for or against the bill. Representative Petty, would you like to close for the bill?
Yes. Thank you very much, Mr. Chairman, committee. This was a very delicate issue to me a couple of years ago, but I appreciate everybody that's worked together. This bill is a bipartisan effort. It just will touch and change many lives, and I would never, ever have even taken this on if I didn't think that this was the right thing to do. I appreciate everyone that worked with me. Representative Letting, thank you. Senator Ervin, and you fine folks. But I just want to close and say this is a serious, serious issue, and I don't take it lightly. So I would ask you to give a due pass on this.
All right. And that's a motion due pass?
Yes.
Okay. We have a motion due pass. Is there any discussion? All right. All in favor say aye. Aye. Any opposed? Motion passes.